Got a particularly old debt and wondering if it still counts? Let's look at how long debt collectors can try and collect debt in the UK and what you need to know. Just to be clear, I don't give financial or legal advice, I'm just making sure that you have access to the information that you need to make informed decisions. How long can you be chased for debt under statute barred law? Statute barred debt refers to debt that has now become unenforceable because the time that is given to a creditor to chase their payment has now passed. However, this does not mean that you can ignore your creditors and/or debt collectors for 6 years and expect the debts to be written magically off. The limitation period starts from the last time you were in contact with your creditors. This can mean anything from when you last made a payment towards your debt or you last acknowledged the debt. So if your creditor is contacting you, ignoring them will not start your limitation period. The limitation period only counts when your creditor is not making any attempt to get their payment out of you. So, under the UK's Limitation Act of 1980, a creditor has 6 years to chase most unsecured unpaid debt, or 12 years for some mortgage debts. I must reiterate that for these 6 years to count, you must not have submitted a payment or made an acknowledgement of your debt to the creditor, not even once. The limitation period does not count in the time during which you have been making payments to your creditor. Ultimately, that means debt collectors cannot enforce their debts through the courts after 6 years. But if you've already been taken to court and have a CCJ registered against you, then there's actually no end date for how long you can be chased. The Limitations Act of 1980 does not cover all types of debts. For example, debts that you owe to the Crown, such as income tax, are always enforceable. How do I know if my debt is statute barred? Here's a quick checklist for you to figure out whether or not your debt is statute barred. You do not have a county court judgment registered against you. You have not made a payment to your creditor or any debt collection agency that they've hired over the last 6 years. You or your partner, in the case of a joint debt, have not acknowledged the debt in writing in over 6 years. If you meet all of these conditions, then that means that the limitation period has passed and your debt should be statute barred. Does a debt being statute barred mean that it's written off? The short answer is no. It's very important for you to understand that a debt being statute barred does not mean that it's been written off. It just means the debt collector can't take legal action to force you to pay. The debt will still exist in your credit file and will continue to impact it negatively. Not to mention that for certain types of debt, even if your debt is statute barred, your creditor can still legally attempt to ask you to pay up using other actions that don't involve a court order or a judgment. Of course, the best way to deal with any debt collector is by sorting out your finances before things escalate. If you're struggling with debt, then there are options available here in the UK. Some are free to use and others include fees, and each will have their own pros and cons. If you want to learn more about the solutions available, then we've created a really great form that you might be interested in checking out. Click the link in the description to get started and answer a few multiple choice questions, like the total amount of your debt, how many people you owe, your living situation, and we'll connect you with one of our trusted partners so you can find out more and start taking steps towards improving your financial situation.